Last three appeals to be heard together on today's calendar: People v. Marina Viviani, People v. Justin Hope, People v. Nicole Hodgdon. We'll start, of course, with the special prosecutor, if you would, counsel.
Thank you, Your Honor, and may it please the court, Caitlin Halligan representing the Justice Center Special Prosecutor. I'd like to reserve 3 minutes for rebuttal, if I may.
You have them.
Thank you, Your Honor. The Attorney General asked this court to take the extraordinary step of holding that the legislature may not authorize the governor to appoint a special prosecutor with concurrent jurisdiction over crimes against a particularly vulnerable group of New Yorkers.
Counsel, if the court disagrees with you, as I understand one of the core arguments you're making, if the court disagrees with you regarding the governor's authority, right, do you then lose the case? Does your entire position turn on whether or not we agree about the governor's authority?
Absolutely not, Your Honor, because what's at stake here is a decision by both the governor and the legislature. The legislature here exercised authority, which this court has confirmed repeatedly, and the Constitution also makes clear that it has to allocate prosecutorial duties. Nothing in the Constitution allocates prosecutorial power to any public official. And so that is reserved to the legislature.
We have said, Counselor, right, that it is the core function of the district attorney to prosecute. That's what they do. And of course, the Attorney General constitutionally had that authority.
Well, Your Honor, the Attorney General under Article 5, the Attorney General's functions can be diminished, set by the legislature. But to go to the question about the district attorney, and specifically to focus on the cases that Your Honor and the Attorney General referred to in Your Honor's dissent in Davidson, I'd like to address those if I can, because we think that they provide no basis for curtailing the legislature or the governor's power here. And there are two sets of cases. The first is Wogan, and the second are Schumer and Haggerty. So I'd like to address them both. First of all, with respect to Wogan, the Attorney General says that allowing the special prosecutor to exercise concurrent jurisdiction, but to do so independently with the safeguards present in the statute, runs afoul of Wogan. It is not applicable here. Wogan makes clear that what was at stake there was a complete transfer, and I will quote here, of all real authority of a constitutional officer. And the legislature there vested, quote, all of the powers with a different statutorily created officer. And that meant—
If I might ask a question at this point. Counsel, just to stay with Wogan, I'm sorry to interrupt, but as I understood Wogan, it was a county clerk position, and what they had transferred, let's call it, to this deputy was for the county court clerkship. And I'm not sure I'm quite clear on what that meant. I thought that was a portion of the overall role of the county clerk, this clerk of the county court portion of that in Wogan. So I didn't read it, and I might be misreading it, to be that they had transferred the entire duties of the county court, the county clerk position.
I think the best reading, Your Honor, is that all of the duties were transferred, because the court says that the legislature can't transfer, quote, all real authority and authorize the new clerk to fulfill all the duties of the constitutional clerk, quote, to the exclusion of the county clerk. So I think the fairest reading is that it was the entire basket. But in any event, Your Honor, what is done with Section 552 is a very small slice of powers that would otherwise be given exclusively to the district attorney.
Well, I read actually Wogan a little bit differently. I think I read Wogan as referring to the essential functions. And yes. So whether it means, you know, everything or just a certain authority that the constitutional officer has. And I, you know, so I think with your reading of the statute, the question becomes, even if it's concurrent authority or whatever, what is the essential function of a DA? is it the discretion of who, when, and how to prosecute someone? And if that is the case, then why isn't that the case with this particular statute?
So the duties of the district attorney, Your Honor, are set forth by the legislature in County Law 700. And what the Attorney General is suggesting is that under this court's decision in Schumer and in Haggerty, that none of that power can be transferred to another official. That's not what those cases say. Both of those cases make clear that what can't happen is that neither the Attorney General nor the district attorney can freely transfer powers that have been given to it by the legislature. But the touchstone is what the legislature has decided. Here's what Schumer says. Schumer says that the powers of the district attorney are conferred upon her by statute, and that the transfer may be accomplished only by executive or court order. And there cites two provisions which do transfer powers from the district attorney, Section 63.2 and Section 701. So that's exactly what happened here. The legislature transferred a small piece of the district attorney's power concurrently, not exclusively, to another officer, and that's exactly
that's I think the point. I mean, or part of the point is that the DA and the Attorney General have historically been given prosecutorial powers. And, you know, I'm not aware of any historical use of such powers by the governor. And so when the legislature gives the governor the power to say, okay, in this particular instance, I'm going to give the DA's authority to the AG, that's really transferring from one of those two historical prosecutorial offices to another. And is a little, and you know, and that would certainly be as far, you know, under Section 63, what generally occurs. So that seems to me to be a little bit different from what we have here.
I think that
Judge, in just to follow up, and then you can answer. I don't mean to cut off your answer, but the way I read Haggerty, it's a 97 Court of Appeals case. It referred to the essence of the DA's authority as a discretionary power to determine who, whether, and how to prosecute. It seems to feed directly into a refinement of the analysis that took place in Wogan and to support Judge Stein's point.
I would disagree, Your Honor. Here's why.
Okay.
Haggard, as well as Schumer, make clear that the question is, what has the statutory framework set forth? So in Haggerty, for example, the court there holds that an assistant attorney general can assist a district attorney, that it does not run afoul of Section 6312. There is nothing in Haggerty or in Schumer or in Wogan, for that matter, which suggests that the legislature is barred, constitutionally barred.
Well, let's take a step back, though, for a second. Concurrent authority means that different prosecutors can do different things on the same case. Doesn't that create a nightmarish public policy scenario for dealing with social problems that arise? It doesn't make sense, that argument.
Well, Your Honor, I think that the experience of the special prosecutor shows exactly the opposite. And I would draw Your Honor's attention.
Well, I would stop you there. I think that's because the people involved are reasonable, intelligent people who are trying to do the right thing with a difficult problem. I think you're right about that they've conducted themselves fine. I don't think that's the problem. The question is not for how they particularly conducted themselves here. I think the question really goes to the core of what could happen in the future, and concurrent authority in a prosecutorial setting would seem to be contrary to basic principles of public policy, because then you could pick and choose your prosecutors.
Well, Your Honor, a couple of responses to that, if I can. First of all, with due respect, the public policy question is one for the legislature to address, and it has addressed it here. And the legislature here acted unanimously. It has only set up special prosecutors 3 times in the state's history. And each of those three incidents were in the face of very serious problems, which it felt it could only solve with that approach.
Yes, but each of those times it was between, you know, there was it was between the AG and the DA and their people working under them or with them, right? And that's exactly the question that we're asking here is that kind of supervision, maintenance of retention of ultimate responsibility. Do we have any examples of when that wasn't the case, in which the court has approved that kind of arrangement?
Yes, Your Honor. I'd like to set to the side for a moment, if I can, the question of ultimate authority and come back to that retention of authority. For this court to hold that both the legislature and the governor are completely prohibited here, I think there needs to be something specific in the Constitution. There is none. You asked if there are other examples. County Law 701, as well as the two statutes that provide for filling of a vacancy of a district attorney's slot, which is Section 496 and the 400 and 926.
But don't both of those apply in situations where the DA, for all practical purposes, either is literally not there, the position is vacant, or cannot act in the role of the DA because of some other limitation?
That's right, Your Honor. But the question here is whether or not the Constitution prohibits anyone other than the AG or the DA from exercising prosecutorial authority. And so the answer to that is yes or no. And it cannot be the case.
So, counsel, let me interrupt you there. I'm going to circle back to, I believe, where Judge Fahey was trying to go with his inquiry. So let's assume we agree with what you just said. Let's just go with that for one moment. So where does that end? Isn't the logical sort of extension of this argument where we end up is that the legislature can take any kind of case at any time, an entire class of case, away from the district attorney? And if that is true, why isn't that really an evisceration of the core responsibility of that constitutional officer, one who is elected, not appointed? And that's my problem eventually with your rule. No, that's okay. You'll have time to answer, please.
Right. So Your Honor, when we started our exchange earlier, you said, assume we disagree with you about the governor's authority. I would say, first of all, I think there is a strong argument, and this court suggests so in Johnson, that the governor's take care power provides authority to do this without the legislature acting. With respect to the legislature, I would say that there is no reason to think that the legislature, which acted unanimously here, which is unusual, and has done so very sparingly, would enact a series of statutes which strip the district attorneys of all prosecutorial power. And I would also say to you that—
Yes, but again, we're dealing with the doctrine. If we adopt your view, if we adopt your view, then there would be no way that they could see their powers otherwise. They could see their powers, they can remove anything. I'll take a historical example, right? Domestic violence historically has been one where there has been some reticence from law enforcement to prosecute. So there were legislative changes to address that. But that entire area was not taken away from district attorneys, right? Because that would have eviscerated their core responsibility to prosecute. So it is a point well taken, of course, that you make, and you see it, of course, in the purpose of the legislation, that the legislature is trying to respond to these challenges in a way that it deems appropriate and fair. But under your approach, there is no end to this.
If I may just respond.
Yes, of course.
Your Honor.
Yes.
I am fully confident that if the legislature ever acted in a way that, as you suggested, took away a wide swath of the district attorney's power, that this court would stand ready to ensure that that constitutional office is not eviscerated. That's what the court did in Wogan. when all of those powers were transferred.
Yes, but counsel, and it'll be the last question, so we can let the other attorneys have their opportunity and you have your rebuttal. But counsel, at what point is too much?
Well,
Two other categories of crimes? 3, 4? Where do we draw that line?
Your Honor, not here is the answer to your question. And if, for example, the legislature decided to strip away all violent crimes, this would be a much harder case. It's not where we are, Your Honor.
Judge Rivera, I'm sorry.
Yes, go ahead.
Out of left field for Ms. Halligan. I didn't want to derail the prior discussion. Could you explain the procedure by which you became the Assistant Special Prosecutor for the Justice Center and what your reporting relationship is to the Justice Center or Ms. Dunn?
Well, generally, the Attorney General's office would defend a state agency. The Attorney General here has taken the very unusual position that the statute, as construed to allow the special prosecutor independent authority, is not constitutional. And so for that reason, the Justice Center had to obtain counsel in order to represent it in this proceeding. And that is why I am here today, Your Honor, instead of Attorney General.
And you report to Ms. Dunn in that capacity? She has supervisory authority over you?
To Ms. Dunn, yes, who is the special prosecutor who is here with me today.
Thank you.
Judge Rivera, if I could ask one last question.
Yes, Judge.
Yeah, thank you. Counsel, just before we move on, your view on there is this notion that if we find infirmities with the statute that we can read consent and ultimate authority provisions into the statute. And I want to just be sure I understand your position, which I think is if you read the statute as written to provide for the consultation and the notice and also with the general provisions, that alone would satisfy any need for coordination with the district attorneys without having to impose other requirements that aren't in the statute.
Absolutely, Your Honor. And I would also say that the cases which the Attorney General cites, Van Sickle and Sedano, do not provide any support for requiring retention of authority where the person prosecuting the case is designated by statute. And secondly, the other special prosecutors for OCTF and the Special Narcotics Prosecutor, and certainly County Law 701, have no similar requirement. And the uncertainty in terms of litigation and the delays that would introduce would completely thwart the goals of this statute in terms of helping prosecute these crimes in a timely fashion. I'd be happy to address any of those specifics, but I know I've run over my time, whatever the court.
Yes, thank you. Okay. Ms. Pollack? Unmute, please.
I was just asking if you could hear me. Thank you. May it please the court, my name is Michael Pollack. I'm representing Viviani. And the special prosecutor spent most of her argument in asserting that the statute gives a slice of power to the special prosecutor. And in response to that, I would simply read the statute itself, which is Executive Law 522, Subdivision 2C, last sentence. It says the special prosecutor or his or her assistant, quote, may exercise all the powers and perform all the duties in respect of such actions or proceedings which the district attorney would otherwise be authorized or required to exercise or perform. That is clearly in contravention of Wogan. That is all of the power. And I think I'm the only person that raised this issue, but I am asserting that this court actually does not have jurisdiction to hear this case because at the very least, it's a mixed question of fact and law under People versus Warren, 61 New York 2nd, 860.
Well, counsel, are we deciding, aren't we deciding whether the statute is constitutional rather than whether, any facts to do with this case? We don't have to decide those facts, do we?
Well, if the statute is constitutional, the question then becomes, did the district attorney's office comply comply with the statute. And in this case, we had a fact-finding hearing. And the court held, the Supreme Court held that no, the district attorney did not maintain ultimate jurisdiction
So you're suggesting that if we came to that conclusion that it was constitutional, that there are limitations on our review of the determination made by the courts below as to whether they complied with the requirements of the statute, right?
That's what Warren would hold, and this is fact-driven in my case.
But that doesn't prevent us from getting to the broader issue.
Well, it's a mixed question of law, so you would have to decide whether you would exercise your discretion and to review that. But in a mixed question of fact and law, my understanding is that the factual determinations should not be disturbed. So I guess that would not arise.
So let's say we've decided that there is a question of law given this issue about the constitutionality of the statute as interpreted by the special prosecutor that is at issue improperly before us. So let's stay with that for one moment. So then, counsel, is it your position that there is no way to interpret the statute, to save it? It is just unconstitutional. The limiting approach that has been adopted by the third department and that I have discussed in my dissent of Davidson, that there is, or some other way, there is just no way to read this statute and save it.
That's our position. There's no way to save the statute based upon the language I just read to you, interpreting.
But there's also language in the statute that otherwise indicates that the special prosecutor must indeed support and not interfere with the work of the district attorney, must consult with the district attorney. Why doesn't that lend itself to this more cabin reading that, of course, the Attorney General's office has advocated from the very beginning?
Well, I don't see how you get around the other language in the statute, which is they have absolute full authority as a prosecutor without being an elected constitutional officer.
Yes, but the limiting, if I can interrupt, Mr. Pollack, the limitation would be that, of course, if the district attorney consents that they can proceed as the prosecutor, the district attorney having the ultimate responsibility, that seems to harmonize and allow for the special prosecutor to serve as a prosecutor when the district attorney believes that that is the best way to proceed and agrees to the prosecution.
Well, I can't agree with that either, because under Wogan, not only must the prosecutor maintain ultimate prosecutorial authority, the prosecutor, the district attorney, must have the authority to remove the lawyer at will. That's language from Wogan. And under any scenario with this statute, the Justice Center acts independently. In my case, district attorney's office was not involved in plea discussions. They did not appear on calendar calls. They had nothing to do with discovery. Basically, they said, here's your grand jury time, do whatever you want. So we don't know whether, because the ADA in the case didn't testify at the fact-finding hearing or submit an affidavit, an ADA, by the way, who's married to a Justice Center employee, although I don't know why my client was prosecuted, if that was the reason.
Well, now that sounds like a question of fact.
Right, but I was never able to cross-examine that.
Might I ask a question of counsel? So counsel, how would you have us interpret the nothing herein shall interfere with the ability of district attorney's language in the statute? How should we interpret that? I
think that's very vague. I don't think it's applicable language. I think it's countermanded by the language that these special prosecutors have all the powers and perform all the duties in respect of such actions or proceedings. I mean, it cancels out that interference. And if there's consultation and the district attorney gives them grand jury time, then they have full power, even though they're unelected and they're not constitutional officers. The whole purpose of if you read the intervener's brief, I think they lay out a good history of the constitutional conventions that have been held in the state where the concept of expanding prosecutorial powers was rejected over and over again. And the Constitution does not allow the usurpation of the discretionary power also, that whether or not the case should be prosecuted in the first place, that is being usurped because you're having the Justice Center can, in this case, have a employee married to a Justice Center employee, arrange for grand jury time and go to the grand jury. I doubt that Mr. Soares even knew that the case was being presented. I doubt he had the opportunity.
Well, but if we were to read the statute as requiring the DA's knowing consent and ultimate retention of ultimate authority and responsibility, then in that case, if the DA felt that there was something improper about the special prosecutor prosecuting this particular case, then wouldn't that allow the DA to say, I'm going to handle this and I may or may not prosecute it?
Judge, I don't know. There's no remedy in the statute. I don't know if you get into a conflict like that, you'd have to go to court and the DA would have to argue they're interfering and the Justice Center could say, no, we're not. We have the authority to exercise all powers and perform all duties of the district attorney's office.
Counsel, if I may just finish, I think what Judge Stein is describing for you is an appropriate limitation that would say, regardless of whether or not the special prosecutor wants to go in and move forward, if the district attorney decides otherwise, or if the district attorney doesn't approve some of those strategic choices, that it's ultimately for the district attorney to decide. And if this court renders a decision that says so, that resolves the issue. I believe that is what Judge Stein was trying to discuss with you. Why wouldn't that be an appropriate way to read the statute to preserve the core functions of the district attorney, achieve some of the purpose of the legislation, and protect the defendant from, someone who doesn't have jurisdiction trying to prosecute them?
Because you still have...
And as part of answering that question, I have a slightly different one, which is, why isn't what Judge Rivera and Judge Stein asking simply rewriting the statute as opposed to saying, well, legislature, you've passed an unconstitutional statute, go back and try it again. And you might want to write in some of the protections or not that are discussed in the Davidson dissent.
Well, I imagine that's what will happen if the court finds the statute unconstitutional as written. The court can set forth under Wogan what the parameters are. I don't see how that can happen unless the Justice Center prosecutors become employees of the county district attorneys under Wogan, because they must be removable at will. And that's from the decision. That's part of the criteria. I'm all for having more prosecutors protect the needs of special victims, but there are other ways to do it. You can hire more assistant district attorneys. There's the whole question of a unelected prosecutor having statewide jurisdiction when the Constitution clearly requires diffuse power between the county district attorneys. That's part of they're each elected, they are each accountable to their constituents. And the decision to prosecute somebody for a crime obviously is an extreme power. And before you can grant statewide power to all the offenses that the Justice Center can prosecute, which is all of Article 130, there should be some kind of control and supervision by a constitutional officer. That's our position. I don't think, as a factual matter, the Justice Center satisfied any of the criteria in Wogan. They were given the opportunity here to establish those facts, that there was consultation. The prosecutor who gave the grand jury access to the Justice Center declined to testify or provide an affidavit. So they have not met the burden under Wogan. And they couldn't anyway, because the Justice Center employees are not removable at will. And the statute has given them far too much power to exercise all prosecutorial powers. which usurps a constitutional officer's authority under the Constitution.
Thank you, counsel.
Thank you, Judge.
Yes. Counsel?
Thank you. May it please the court. My name is James Bartosik. I'm from the Albany County Public Defender's Office on behalf of respondent Nicole Hodgdon. And I'm asking the court to affirm the third department decision upholding the county court's dismissal of the indictment based on unconstitutional prosecution of the defendant. I think on its face, there are a lot of different things that the legislature could have done constitutionally to alleviate some of these issues that it found. But the Executive Law 552 is not one of those things. And I think that's inherent in the language of the statute, first of all, that it's not described as a district attorney in the statute, and that it actually has district attorney powers, which are problematic because they're typically reserved for the district attorney or the attorney general. And as Mr. Pollack was suggesting, the electoral issue is certainly important to this analysis. This court has found in prior case law that there's an implicit understanding in the New York State Constitution that all prosecutorial power for criminal offenses is reserved for attorney generals or district attorneys.
Counsel here for a second. So could you respond, you may have already just done that, but to Ms. Halligan's argument that you can't find anywhere in the Constitution that prohibits the legislature from creating essentially another prosecutorial agency. You use the word implicit. If it's implicit, is there anywhere you would direct us for that implication?
Your Honor, I would just, it is implicit based on the fact that and I mentioned this in my brief, but the fact that the framers of the New York State Constitution created the Attorney General's position and the District Attorney's position and specifically made them electable positions, right, with certain terms that can be removed, that implies that the prosecutorial power is reserved to those two. Otherwise, the framers of the Constitution would have provided for another prosecutorial agency that had, again, concurrent jurisdiction or concurrent authority with the district attorney and the attorney general. And there is no provision for that.
I'm not sure I agree with your characterization that they created only the AG and the district attorney because the AG existed as an officer back in colonial time. When you go back through how we got to where we are in our current Constitution. So certainly the AG was the supreme, if you will, prosecutorial agent. And then later they created district attorneys. And so the question is, why can't the legislature, along with the executive, now create yet another type of prosecutor? What is the language in the Constitution, the current version, I know it's been through a lot of iterations, that forbids it?
Your Honor, I don't believe there is any language that forbids the legislature, but my argument or my understanding is that had there been the authority for another agency to act as a prosecutor of these criminal offenses, then the Constitution would have provided for that. Otherwise, the prosecutor has to act as a subordinate to either the Attorney General's office or to these local district attorney's office. And that's exactly what has been happening in many of the cases that the Justice Center has mentioned in their briefs. The governor has that take care clause. It's not, there's no debate about the take care clause and the governor being able to appoint a special prosecutor. But historically, the governor will appoint the Attorney General's office to prosecute crimes in select areas when there's an identifiable need. And in this case, the governor could have appointed a special prosecutor to prosecute these crimes that were identified by the legislature if they had done it under the Attorney General's office and created a special wing subordinate to the Attorney General.
A question here. I think Judge Feynman's question is an important question because I think it's clear in my reading of the Constitution that we're not referring to a constitutional provision that's definitive here. In the same way that when we talk about the governor's power, we're talking about the takes care power it's referred to. None of those provisions are definitive in terms of the exercise of this power. Instead, it seems to be the argument is based on what are referred to as state constitutional principles. The ultimate constitutional principle here is that the way I understand it is that you cannot diminish the power of an elected official. And that seems to be the theory that runs through cases like Wogan and Haggerty and Sodano. And so is it a more correct answer here that there is not a constitutional provision? Judge Feynman is correct. Instead, there are state constitutional principles that are expressed from constitutional phrases and state and case law that consistently say that you cannot diminish an elected official's position, or authority, because you are undermining the people's elected representative, which is uniquely distinct from any appointed representative that comes up. And that to do that in that context means that one person has to be the ultimate authority. And to have one branch of government take away another elected official's powers or authority is to undermine that very fundamental principle of democracy. Isn't that what we're talking about here? We are talking about, Judge Feynman's right. I couldn't find a constitutional principle that specifically says the DA has this power and you can't take it away from him. Instead, what we have is a principle that elected officials' powers cannot be diminished.
I wholeheartedly agree with that, Your Honor. And I think that it is not in the Constitution. It is something that's implicit, something that's historically derived, and something that has been evolving over the course of, several
and you can
hundred
see
years.
why it doesn't then make it as hard and fast as we like these arguments to be. It's a more difficult and a more nuanced argument as a result.
Certainly. And I think part of the Attorney General's office, I'm sure Ms. James will have much more to say about this, but part of that theory is that this statute works only if the special prosecutor is subordinate to the local district attorney. And the question I think for this court then, and as it applies to these facts for both Hodgdon and Viviani, is that if the special prosecutor is subordinate to a district attorney, then what is the constitutional requirement to render the special prosecutor subordinate, right? How does the special prosecutor act in a subordinate manner? And that, I think, has been developed by this case law, Sodano and Van Sickle cases, where it has been deemed acceptable that the district attorney can allow others to prosecute if kept aware of criminal prosecutions in the county. And in those cases, it was very presumptive that they allowed others to prosecute cases. And there was no real basis in those cases to suggest that the district attorney's office was even aware of those criminal prosecutions. And this case and the Viviani case flipped that line of case law on its head, because the chief assistant district attorney of Albany County affirmatively states that it never allowed or consented, despite its awareness of the Hodgdon and Viviani cases and the Hope case, and did not retain ultimate responsibility, which was one of the requirements in Sodano. And so if the district attorney office can definitively contradict that awareness, that retention of ultimate responsibility and consent, then how can awareness be considered permission or consent in the future? And so I think that's what the third department was referring to in its decision when it interpreted Judge Rivera's affirmative Davidson opinion requiring notice, consultation, and consent, and holding that was required knowing written consent and retention of ultimate responsibility. And I think that is the correct standard. That I think the facts of this case show that an affirmative standard is necessary to prevent prosecutions that would actually be valid under the Van Sickle and Sodano standards, but in fact are unconstitutional. And so under these facts, I mean, under any of the standards, whether just notice, consultation, and consent, I think that the Justice Center failed to just, as Mr. Pollack noted, to provide any support for that. But there was no actual, consent agreement, no language indicating consent. And then the fact that the district attorney's office actually came out and affirmatively stated that it never consented to the prosecution renders the special prosecutor's actions in this case completely unconstitutional. So even if it couldn't be construed in a constitutional manner, I think that the Justice Center never lived up to that. And I think it has, as a result, become a more difficult standard for a special prosecutor.
No one else has any questions? Thank you. We'll move on to the Solicitor General. Good afternoon.
Good afternoon. The question, we've been talking about where in the Constitution does this restriction to the DA and the Attorney General come from. The district attorney, first the Attorney General alone, and then the antecedents of district attorneys were the only state prosecutors in the colonial period and in the early days of the Republic. And that role was recognized when they were placed into the Constitution in 1821.
Counsel, I'm sorry, Judge Rivera, if I may ask, do I have this history right? And your material is very helpful, but the Attorney General really was the only constitutional law enforcement officer, and then the legislature began to create district attorneys by statute that didn't report to the Attorney General. Is that right?
In 1664, the AG was the only prosecutor. In 1796, there were entities called, or there was an office called Assistant Attorney General, but
they didn't report to the Attorney General.
Correct.
It wasn't, and then they turned them into, as I understand it, district.
Yes, that's right.
Why wasn't the legislature doing then exactly what you say they can't do now? Because wasn't the Attorney General a constitutional officer at that time?
Well, we have a different constitution now, and neither,
but in a material way,
neither the district attorney nor the Attorney General was in the Constitution at that point. So they don't get named as constitutional officers.
So they were just carried over. The Attorney General was just carried over in the 1777 Constitution? That's
correct. And they first appear in the Constitution in 1821. So we have these offices and they aren't named in the Constitution. And then at the point at which they are, it's the second Constitution, I guess, the DA and the Attorney General are named in the Constitution, and the DA at that point was to be appointed by the courts and the Attorney General elected by the legislature. Provisions about the DA and the Attorney General first appear in the Constitution after some period of time, and therefore those names, those positions, take their meaning from the practice that has preceded it. So I think that, and then what happens is in 1846, they both become elected officials. There continue to be provisions about how they are to be selected. They're never defined terms, but I don't think you could make the district attorney's functions only be dog catcher or the Attorney General.
May I ask a question?
Yes.
Judge Rivera?
Yes.
Thank you. Counselor, this is a little moving a little beyond this core discussion, but there's something that's been sort of perplexing me, and that is that if we agree with your position about what is required to, what reading of the statute is required to make it constitutional, would we be calling into question the constitutionality of the organized crime task force provision, which requires the consent of the or approval of both a DA and the governor?
Not at all.
Why?
Because the governor's role, the organized crime task force, is lodged in the Attorney General's office, is headed by a deputy Attorney General, and the governor can do nothing with that alone. It is also true that the Attorney General and the DAs can't do anything alone. There's a collaboration here. The governor's executive power is implicated, but the governor cannot appoint a director to the
But
organized
isn't
crime
that
task force.
diminishing the authority then of the AG?
I don't think it is. I think that the governor's participation in the decision does not render this person not a deputy attorney general. The governor, I mean, I'm familiar with the stalemates that can arise, but the governor cannot appoint a deputy for the organized crime task force without the agreement of the attorney general, nor can the attorney general appoint without the agreement of the governor. And so eventually they come to an agreement. But the person who is appointed is therefore consented to, approved, and appointed by the attorney general.
And then what is the nature of their power and relationship with the governor post the appointment?
Post-appointment, the governor's role is that he can prevent, his approval is needed for a prosecution, but for going into the grand jury and commencing a prosecution, but so is that of the DA. So again, he's got a veto power, but he cannot appoint a director and he cannot commence a prosecution. He can block the appointment and he can block a prosecution, but he cannot actually affirmatively bring a prosecution or name a head of the organized crime task force.
And the governor's powers vis-a-vis the organized crime task force, they derive their constitutional support from the take care clause or from where?
Well, I think you would say the take care clause. I don't know that this court or anybody has identified the source of that power. The reason OCTF is in the law department is that it was widely understood at the time that no statewide prosecutor could be created other than in the Attorney General's office. That's the one source of support for that is the McQuillan letter that's in our addendum at page 4 and 5. It was generally understood that while some proponents of the Organized Crime Task Force wanted it to be freestanding, they felt that the Constitution prohibited. So there's been a long tradition of an understanding that the only prosecutors in the state have to be exercising authority either of a DA or of the AG, and that the only statewide and the DAs are countywide, and the only statewide prosecutor is the AG. And OCTF fits squarely within that model. And then
if I might ask counsel a question. Ms. Underwood, so turning to your sort of the saving construction that you're proposing, how, if at all, is that different from the process and the supervision that Ms. Halligan described that allowed her to be appointed? I'm putting aside the question of whether Ms. Dunn had the authority to appoint anybody at all. Take the Attorney General as an example. You can appoint a private attorney to prosecute a case, but the Attorney General, in my understanding, has to retain supervision and ultimate decision-making authority. Is that any different from your saving construction?
Well, the difference, the principle is pretty similar. The difference is that there is an institution called the Justice Center that does many things, that has brought together a group of people who have expertise, that has resources that are appropriately and desirably devoted to all of this. And the benefits of having this standing institution are great, but the same features that make it, the fact that it's a standing institution makes it problematic as a prosecutor. And so it's individuals. Ms. Halligan's firm, I don't believe, has been appointed by the special prosecutor.
Right.
So the individuals could be cross-designated as assistant district attorneys. That's one way to solve the problem. Another, though, would be to just interpret this statute without having to cross-designate them as permitting them to prosecute with the approval and ongoing right to retain control of the relevant district attorney.
And I guess that puts a point on my question, which is, I don't believe anybody is arguing, you're not taking the position that the entirety of the Justice Center is unconstitutional. They have a myriad functions. It's really, we're talking about the ability to prosecute independently.
Correct.
And so my question really is, were we, and I don't know what we're going to do, but were we to conclude that the statute is not constitutional as regards the prosecutorial power, couldn't your office or individual district attorneys designate individual members of the Justice Center to prosecute cases?
Absolutely. I mean, there was a model for a while for that sort of backup center when a capital case backup center was created with resources and expertise. There were prosecutors who staffed it. They provided training, and they sometimes were cross-designated by district attorneys.
Do you know any policy reason why this organization wasn't placed within the Attorney General's office?
I'll just speculate, because I don't know, that there was an interest in establishing the principle that the governor can create an independent, freestanding prosecutor, and that it was attempted in this case. I want to say that over the years, there have been numerous proposals for special prosecutors independent of the DA and the AG. They have not been implemented, at least in part because of constitutional concerns. They include proposed special prosecutors for violation of the election law, a special prosecutor for bias crimes, a special prosecutor for deaths caused by police officers. And when the controversy about the constitutionality of those has come up, in my experience, people have said, well, they could do it for this special prosecutor. I guess I guess it's okay. So whether that was in the minds of the creators of the Justice Center when they did it in the first place, I don't know. But I do know that it has since then been invoked as precedent for creating other independent special prosecutors.
Counsel, if I can go, let me just ask this follow-up. I'm sorry, Judge Fahey. I go back to this cross-designation that you're talking about. So is what you were describing in response to Judge Wilson's question that whoever's already on the staff or whoever might be hired on the staff of the Justice Center for to serve this prosecutorial role would not be able to seek out the DA, but the DA would have to seek them out? Is that what that would mean?
I don't think there's a restriction on who initiates the contact. The DA would have to agree to cross-designate. But
I guess I'm sorry. I guess this is what I'm not understanding. When you say cross-designate, is that a particular term of art in this context, or is it just the special prosecutor reaches out and says, we're interested, we've done this investigation, we're interested in prosecuting, and the DA is informed, comes up to speed on the facts and the issues, and consents, let's say puts it in writing, let's take that off the table, to the office, the special prosecutor taking that on, retaining in the DA's office the ultimate decisions in that prosecution? My understanding of the usual way the term cross-designate is used in both federal and state practice is an appointment of an individual from another office to be, for the purpose of a case or a series of cases or whatever, an assistant district attorney or an assistant U.S. attorney or whatever it might be. That's one way to do it. But you could, I think, consistent with the Constitution, do it a different way, which is what we've proposed in this savings construction, which is to simply have a consent to the institution that was created by the legislature, approved by the DA to prosecute. Yes, because in that cross-designation, if I'm understanding you correctly, then the person is no longer an assistant special prosecutor, whatever the term might now be.
No, they are. They're just cross-designated. I mean, it's quite common for, well, in fact, it's what happened in the case, I think it's Haggerty, I'm not sure the name of the case, but the case in which people from the Attorney General's office and actually the Attorney General were cross-designated as assistant district attorneys to assist the district attorney in a particular case. And this court said that was fine. You didn't need a governor superseder. It was okay. The attorney general could lend support to the district attorney by having some assistant attorneys general cross-designated, in other words, appointed as assistant district attorneys for the purpose of a particular investigation or a particular case.
Would that approach leave open if a district attorney says, I don't want to cross-designate, but I'll pursue, I'm comfortable with the other approach, which is I'm willing to consent in writing with ultimate responsibility for the case?
Well, I think that both methods would satisfy the Constitution. There'd be a question about how to read the statute if we were going to use going to try to read something into the statute, or for that matter, if the legislature were to rewrite the statute, that would be another possibility.
Right, it does seem to be somewhat problematic. It doesn't seem to be the intent, this cross-designation, given, putting aside the language about concurrent authority, this other authority about, or this other requirement that it seek out, it notify the DA, it do seek to assist with the DA in a different way. It is true one could massage that, but it does seem to me that on this point, Ms. Halligan is correct, that what the legislature is seeking to do is really designate this other office with these other officials. But I understand your point.
I think that's right, but I think there's nothing in the law that would prevent, in fact, Ms. Halligan can answer this, but the special prosecutor, the Justice Center has, for a couple of years now, been operating in a world in which the third department's rule is the law, and I would imagine that they have found a way to bring their cases to the district attorneys, either to be prosecuted by the district attorneys or to be cross-designated as assistant district attorneys to prosecute them themselves. I don't really know what they've done.
So that I'm clear, excuse me, Paul, I'm sorry. Just so I'm clear, if your proposed remedy is considered by the court, are you asking us to say that not that this was facially unconstitutional, but the statute was unconstitutional as applied here, but it would be saved by this construction?
Yeah, I guess I would write it a little differently if you're asking.
Well, how would you write?
I would say it would be unconstitutional if construed the way the special prosecutor has been construing it, which is to give them complete, unfettered, independent prosecutorial authority. But in order to avoid that constitutional concern, we construe it to include a requirement of district attorney approval and continuing responsibility. And we read that into the provision that says nothing the special prosecutor should do should interfere with the district attorney, and they have to notify, consult about some things. And
you don't have to write the whole opinion, Ms. Underwood. Just this one part I've got a question about you. Right?
Okay.
All right. Thank you for your response.
Okay.
And maybe follow up with that a little bit. I'm sorry. Go ahead.
I think Judge Feynman has.
Well, why don't you ask your follow-up, because mine actually goes back to the cross-designation issue.
Yeah. No, my question is simply, do we need to, it's not clear to me what retention of ultimate responsibility exactly means. Are we saying that would you have us say that the DA, would have would have to dictate or give consent to specific decisions taken during the course of a prosecution, like what witnesses to call, which evidence to use, or what sentence recommendations to make? How granular do you think the court would need to get if we agreed with your position?
The DA need not monitor every decision made in a case any more than the DA is required to monitor every decision made by his or her own staff in a case. The DA can supervise as they see fit, can defer to discretion as they see fit, but they have to have the ability to overrule when they feel moved to do so. And somebody said they couldn't fire. They could fire. They can't fire a special prosecutor, an assistant special prosecutor from employment, but they could, for instance, withdraw their consent in a case of disagreement to the continued representation by an assistant special prosecutor. Now, I will say that the special prosecutor has said that there's already a great deal of consultation and collaboration, that they've said at various times in the course of the years we've been litigating this issue that they rarely, if ever, proceed if the DA objects, that there have been few, if any, disagreements between a DA and the special prosecutor. This case, though, is about what happens if and when they arise for this special prosecutor and for any other that is similarly constructed. It's about what the rules are in the event of disagreement. And if they don't disagree, then imposing a requirement of approval and retention of authority shouldn't be very burdensome, but it will provide some guardrails in the event of a disagreement.
That's fine.
So yeah, I just going back to the issue of cross designation. Is there anything to be learned from how the special narcotics prosecutor operates, which obviously there is a special narcotics prosecutor appointed with the consent of the 5 city district attorneys, and it's staffed by all these ADAs from across the 5 counties. I believe they use a cross designation, between you are an ADA in DA Vance's office, and you are a cross-designated as an ADA in Bridget Brennan's office. The office of the Special Narcotics Prosecutor. Is there anything to be learned from that in response to Judge Rivera's questions about cross-designation?
Well, I'm not sure about the mechanics of all of that. I do know that Bridget Brennan herself, the special narcotics prosecutor, is an assistant district attorney. And the independence and the respect that she has is simply what she has earned. There is authority in the district attorneys to fire her. There is authority to overrule her. It works as as one would expect. The special any expertise, any person who is in charge of an important area of work, to have considerable respect from the head of the office. But there are ultimately differences of opinion, and somebody has to be in charge. And the special prosecutor has insisted consistently that in the event of disagreement, they are in charge. And we are saying that that is what violates the Constitution, because they are not one of the constitutional prosecutors.
Judge Rivera, if I might just ask one last question. Counsel, I'm just having trouble finding, the third department, for example, said you didn't have written consent here. Finding these terms in the statute anywhere. And my understanding of the avoidance doctrine was you could look at a statute, and if there were 2 ways to interpret that statute that were reasonable, we would go gravitate towards the one that would save the provision from a finding that it was unconstitutional. But we've always made clear in those cases that we wouldn't rewrite a statute. And I don't see how, for example, we can put in a requirement of written consent based on that amorphous provision, which actually goes against some of the other provisions in that statute, and say, well, if you have a written consent here, it's required, or if you retain ultimate authority, then that's okay. And I don't know of an example of any case where we've done that. In fact, the only one I found that was somewhat analogous was in People v. Smith, where the court was considering the constitutionality of the death penalty in New York. The Attorney General's office came in and made the argument that we could read in a mitigation consideration of mitigating factors into that statute and save it. And Judge Kaye said, that's not our job. We would be rewriting the statute. And when I look at this statute and I hear written consent and retention of ultimate authority, I think of that same response, which is they may be very good provisions to have in here, but the pen is with the legislature.
Well, this is my response to that complex of questions, which is, I think the specific requirement of written consent would be impossible to find in the statute, but I also think that that is an evidentiary point. What is required is consent, and it is a matter of prudence, and courts sometimes explain, sometimes impose evidentiary or procedural rules to implement the rules. The rule would be that the district attorney has to have approved it. And I think you can fairly read that into the sentence that says nothing herein shall interfere and so forth and so on. So I would treat the third department's rule of written consent just as a rule of administration, a rule that makes it easy to document that there actually was consent. And you know, as I say, a letter, a simple, probably they would develop a form, you know, a simple letter would ordinarily do that. Ms. Halligan has said that in our papers, we said in the mine run of cases, that's meant to just reserve the possibility that there might be blatant extrinsic evidence that there wasn't in fact consent. You know, there might be, as for instance, the chief ADA Rossi's affidavit in these cases in which he said he didn't think he had authority, he wasn't making any judgment, and so you can't read his letter as expressing consent. But ordinarily, you could read a letter, particularly if this court says that the statute requires, in order to save its constitutionality, the statute requires DA approval and ultimate authority. We're talking about law enforcement officials here. Presumably they will do what they're told the law requires.
Certainly we would think they would do something to avoid the prosecution going nowhere and being overturned.
Exactly right. Exactly right.
Unless there's another question. Thank you so much.
I'd like to say just one thing, if I might, just in closing. I want to make it very clear that the AG is here and in these cases not to protect anybody's turf, and certainly not to undermine the mission of the Justice Center. We're here to fulfill our responsibility to the rule of law, to defend and enforce the Constitution, to defend the law of the state of New York, and to reconcile them if possible. And that's why we have urged this court to enforce the Constitution's limitation on who can exercise prosecutorial authority, and also to save the statute and the valuable contribution of the Justice Center to these cases by interpreting it to provide the special prosecutor with a path for obtaining constitutional authority to prosecute.
Thank you so much. Ms. Halligan? You have to unmute.
Sorry.
It's all right. We hear you.
Okay, thank you. My adversaries have made quite a few points. Let me try to respond to a few of them. First of all, there is nothing definitive in the Constitution that precludes the independent exercise of power by the special prosecutor. And I would ask this court to read the cases on which the Attorney General relies, Wogan, Schumer, and Haggerty. They are all about not transgressing statutory lines, not constitutional restrictions. As you suggested, Judge Garcia, the Office of the District Attorney was created by the legislature. The powers are set by the legislature. That's true for the Attorney General as well, and Article 5 of the Constitution says so. As to whether there was some ulterior motive in the unanimous passage of this statute, there's certainly no basis for that, and it would be speculation in any event. I would also add that,
if I may interrupt you, my apologies. How would the legislative purpose not be furthered? That is to say, how is it undermined by the kind of cabining or reading of the statute that the Attorney General advocates?
I'm really glad you asked that question, Your Honor, because I think that this is essential to further the purposes of the statute. First of all, what the Attorney General is saying is that there should not just be consent by the district attorney, but there also must be some mechanism by which ultimate authority is retained. And as I think some of these exchanges demonstrated, there's no way to know what that means. The result of that is uncertainty and delay. And I can tell you, although it's not in the record, that as a result, the number of cases that the special prosecutor has been able to handle has really dropped off, because this really makes it very difficult to negotiate with each district attorney what an arrangement like that might look like. And it also creates tremendous...
Why isn't Ms. Underwood correct when she says, well, look, that's for the district attorney to decide within their office, in the same way they decide what the appropriate oversight and supervision is going to be of an ADA that's working up a prosecution. It's sort of in the same nature. Why isn't that the appropriate response?
I think these cases show why. If you look at the appendix for each of these cases, it is clear that the district attorney, quote, agrees that the special prosecutor will proceed with the criminal prosecution. And for the attorney general, and also for Mr. Pollack and Mr. Bartosik, that is not enough. And so the questions that creates, both in terms of future litigation along the lines of what Mr. Pollack is suggesting, as well as the need to sort that out with each of the 62 district attorneys, means that the resources that could be used to make these cases and to handle these very difficult, challenging circumstances is being devoted.
If I could just follow up on this. Counsel, you would agree, though, that if the legislature had actually put into the statute that the special prosecutor and whoever the special prosecutor appoints within their own office the legislature could have written that person is subordinate to the district attorney, correct?
Well, the legislature can allocate those.
All I'm saying is that the uncertainty that you're talking about is not really an uncertainty. It's inherent in the nature of having hierarchical assignments, and the legislature could have decided the same.
Well, no, Your Honor, I'm saying that by suggesting that there is this requirement, which is not imposed on OCTF or the special narcotics prosecutor, once those cases are charged, then that officer proceeds to handle them independently. So there's not an analog here, and certainly not in County Law 701. So of course there is uncertainty about what that might mean.
Let me ask you this, Ms. Halligan. As I see it, we have three options here. We can either read the statute as constitutional as written. We can read it as not being constitutional unless we find within it a certain limitations, or if you will, such as consent and or retaining ultimate responsibility. Or we can just say, this is for the legislature. We find that this statute is not constitutional as written. End of story. Where does that leave the Justice Center if we do that?
An additional alternative, Your Honor. I think that if you were to apply the canon of constitutional avoidance, you don't need to hold that the statute is unconstitutional if it allows the Justice Center to exercise independent authority. What you can hold is that that's a question that would raise serious constitutional concerns. You don't need to dispose of the constitutional question per se. If that's the route that you take, and as I have, I think, laid out, we don't think there's anything in the Constitution that gives any basis for restricting the legislature and the governor in that way. But if that's the route that you take, I think that you can read it to require consent. I don't think there's any basis as a constitutional matter to require the retention of ultimate authority. And what the Attorney General is relying on is Van Sickle. I would ask the court to look at that case as well. What the court is saying in Van Sickle is, first of all, it says expressly that it's not resolving any question about the DA's rights or duties. And then it says, if that question were before us, the DA would have to obey Section 700. So the only point in Van Sickle is that where the legislature has made a decision, then that's what the district attorney has to abide by. Here,
correct me if I'm wrong, obviously, a former prosecutor that you were. Somebody's got to make the final call on a prosecution. I mean, it literally cannot be concurrent. That's what's, in my view, sort of the core problem with the statute. It cannot be concurrent. Because if the DA doesn't want to prosecute and the special prosecutor does, you don't have concurrent.
So,
right? Somebody is making a decision and somebody's got to decide how that prosecution is going to proceed. So at some point, whether we see it your way or another way, someone's running the prosecution.
that's right, Your Honor. I will say as a factual matter, there are no circumstances in which there's been a disagreement. And the statute provides that as soon as an allegation comes in, the special prosecutor has to notify the DA. But I think to go to Your Honor's core concern here, I take it to be one of who's accountable. And what this court has said in the 1979 grand jury case is that where there is a superseder, for example, the governor is publicly accountable for those decisions. It is also not the case, as the Attorney General suggests, getting to the same concern, that only an elected official can wield prosecutorial authority. The 1846 convention, which is what she points to, made a slew of offices elected. For example, the canal commissioner, the state engineer, for reasons having to do with the crackdown on patronage. There's no evidence it had anything to do with prosecutorial authority. And while that exercise is certainly very serious because of the consequences it can have for any defendant, this court has been clear that the governor and the legislature at the end of the day are accountable for choices made by prosecutors whom they appoint. And that should suffice to address any concerns about some hypothetical disagreement that might arise down the road.
Counsel, if I might just ask a question, Judge Rivera. I'll ask the same question. Do you know of any case from our court where we have read in these types of requirements into a statute under the theory of avoidance of unconstitutionality?
Well, Your Honor, I think that you can fairly, on this point specifically, I agree with General Underwood. I think that you can read the requirement to not interfere as well as the requirements for consultation and notification with respect to a search warrant as embodying a requirement of agreement or consent on the front end.
Well, let's take the search warrant one. As I understand the search warrant provision, you have to give notice to the DA where the search warrant is executed, right?
Correct.
That may not be the same DA that has the ultimate prosecution, right?
Well, I'm not sure why it wouldn't be.
Let's say the perpetrator lives in a different county, right? You search the house.
Hypothetically.
Right. So how could that in any way imply that you have to consent to the DA?
That requirement, along with the grand jury requirement, right, that the special prosecutor notify the DA before she goes into the grand jury, confirms that the legislature expects them to cooperate and for the special prosecutor to not trespass on the interest of the DA. I think that's specific.
But I think that the grand jury one seems to me very much a time and place consultation, right? I think is the language. So I think it's difficult to read a consultation on time and place and a requirement that you give the DA in the location of the search warrant as a consent requirement.
Well, to be clear, Your Honor, I don't think you need a consent requirement.
I understand.
Yes, but on this specific point, I do agree with General Underwood that the statement in the statute that the special prosecutor may not interfere with the district attorney can fairly be read that way to the extent the court thinks that there are serious constitutional concerns about reading it otherwise. And that is something that I think would at least provide some measure of efficacy for the special prosecutor going forward. I would ask this court, especially given the difficulty of these cases, that if the court disagrees with us and finds some basis in the Constitution to prohibit the legislature and the governor from appointing the special prosecutor, that it provides some clarity. It is the uncertainty, which I think this argument has made plain, about what some requirement for retention of some authority might mean, that is very paralyzing. So should the court disagree, we would urge you to provide clarity on that point. The best way to do that, and the way that is most consistent with the case law and the statute, if that's the route that you believe you need to go, I think is to simply say consent is sufficient. And there is consent here. It's set forth in the appendix and the letters of agreement. I'd be happy to answer any other questions if the court has any.
Thank you. Thank you, counsel. Have a very good afternoon.